Attorney General.
Thank you. Thank you very much, Madam Speaker. By way of reply, may I say that my reply has been greatly facilitated, and I acknowledge the remarks which have been made by my colleagues on the government side, member for San Fernando West, and member for Port of Spain South, who have very ably addressed some of the critical points that need to be addressed in the fulsome quality of the debate, which needs to be taken on a bill of this nature and of this importance. By way of introductory remarks, may I first of all address a couple general statements which were made by two of the principal speakers for the opposition. The concept that this bill somehow or the other is invading the privacy of individuals. I find it regrettable that those remarks can have been made, because on a careful reading, and I will come to that in some more detail, on a careful reading of the legislation, both this bill and the Interception of Communications Act, it is clear that the submissions made in that regard, regrettably, are scaremongering as opposed to substantive. The second point of general purport that I wish to make is, and this was dealt with very comprehensively by my colleague for Port of Spain South, there is no erosion of the powers of the Director of Public Prosecution. And I would remind the member on the other side who suggested that he needed to read at length Section 90 of the Constitution so that he could inform me of the text and substance of that section in case I didn't know it. I would remind him that if he goes to the law reports and finds the case of Dhanraj Singh against the Attorney General and Director of Public Prosecutions, he would remind himself that when Mr. Dhanraj Singh, who I believe was a member of the opposition, which may have been in government at the time, but certainly a member of the current opposition, when Mr. Dhanraj Singh brought that constitutional motion dealing with an accomplice witness who had been charged with murder, I appeared for the Director of Public Prosecutions. And the judgment of Mr. Justice Nolan Barrow in that matter is now part of the locus classicus that deals with the substantive differences between the powers of the Attorney General and the Director of Public Prosecutions. So I don't need to be reminded of the language of Section 90. Nor do I accept in the least the other scaremongering point that has been made to suggest that this bill somehow seeks to erode the independence of the Director of Public Prosecutions. Far from it. And the member of Port of Spain South, as I had started saying, made the point very amply, and I will not repeat it except to just adopt the fact that throughout this bill, you will see that if one takes the time and the trouble to read it, that throughout this bill, the jurisdiction and independence of the Director of Public Prosecutions is preserved by allowing the Director to be served with notice of everything done by the masters once it is done, and reserving to the Director of Public Prosecutions a right of appeal under the Criminal Procedure Act to the Court of Appeal. So there is no question of the Director's independence being eroded. What this bill is about is to get all stakeholders in the criminal justice system to join hands and get shoulder to shoulder in moving forward our criminal justice system. The Director of Public Prosecutions, the police, the public defenders, the judiciary, all of whom have been consulted in the articulation, drafting, and passage of the bill which is before this House. So those are my two general comments, Madam Speaker. If I might just deal with a couple of the points which were made in the first instance by Member of Parliament for San Fernando. I beg his pardon if I get his constituency mistaken. Honourable Rambali.
So, Attorney General, just to assist you, that will be Chaguanas West.
Chaguanas West. Thank you very much, Madam Speaker. If I might address in another place, which I am even still more accustomed to, I would have referred to the member for Chaguanas West as my learned friend. I have to call him by the name which he must be recognized by in this House. And I was about to say, Madam Speaker, that he spent a considerable amount of time on the term appropriate adult that is used in the bill that we are speaking about. But I reassure him that appropriate adult is properly defined and in fact is pointed to in the bill as being appropriate adult as defined by Section 3 of the Children's Act. And appropriate adult means a person 18 years and over who is a social worker, a welfare officer, justice of the peace, attorney at law for the child, any other responsible person with whom the child is comfortable. In the case of a person with a disability, the appropriate professional, but does not include, and then there are a number of exclusions. The short point is that appropriate adult is a person who accompanies a child in appropriate circumstances spelled out in the bill. So I put to rest the concerns that the member appears to have been deeply troubled by with reference to the term appropriate adult. And I will accept, when I went back to page 11 of Hansard, that the record of what I said, either through my fault by being less than clear or by the record itself, may have misled the member into thinking that appropriate adult intended something else. But it is very clearly defined in Section 3 of the Children's Act, and it is used, the language appropriate adult is used with that definition in mind. The wish that there would be better resources to accompany the sea change which this legislation is introducing was another point that was made by the member for Chaguanas West. And the member for San Fernando West dealt with it quite ably. And just by way of emphasis, the short point is that there has been, under the supervision of this government, of which I am very proud to be a part, over the last several years since this government took office in 2015, there has been a sea change of improvements, infrastructural, structural, and other changes that boost the criminal justice system. And this piece of legislation that we bring to this House today is but part of that. So we can look at the backlog identification at all levels of the court and the prosecutorial division, the creation of divisions of court, the introduction of judge-alone trials, the decriminalization of road traffic offenses, the introduction of new plea bargaining legislation, the increase in judicial capacity and support systems, the creation of a public defender system to boost the small criminal defense bar, the enhancement of the prosecutorial system under amendments made to this very legislation in its previous incarnations, the introduction of criminal prosecutorial and procedural rules, and the implementation of a fully computerized case management structure. Only this morning, I signed off with the Embassy of the United States of America on new case data activation equipment that is going to be made available to the Public Defender's Department of the Legal Aid Department of Trinidad and Legal Aid Authority of Trinidad and Tobago. This government is committed to an ongoing increase in the efficiency and productivity of a fair trial system, of which this bill is just the latest in an ongoing process. If I may just turn, Madam Speaker, to some of the comments that have been made otherwise and address them. There is no question that the staffing of the DPP's office continues. There is no question that the DPP's office exists throughout Trinidad and Tobago, and the staffing and outfitting of that department continues. I have myself met with the Director of Public Prosecutions. I think the record shows that on more than one occasion. I am not going to divulge the discussions that started and continue, both with me personally involved and through the agencies of other agencies and persons, but I can certainly give the confident assurance that it is my expectation that the improvements in the criminal justice system, which this bill is committed to, will include improvements in the office of the DPP with the active, ongoing cooperation of the Director of Public Prosecutions. I can say as well, Madam Speaker, that the issue of search warrants is one of the issues that has been raised and seems to have raised some concerns. I have already said in my earlier remarks that I am moving an amendment to address that, and that amendment will seek to ensure that where a search warrant is issued by a master on oath with respect to specific premises, to the extent that the master issues other search warrants in relation to persons who are occupiers of premises, the rigor and strictness with which Section 5.1 of the AJIPA bill before the House today, the rigor of Section 5.1 will apply by the amendment that I am proposing today to the other premises that are authorized to be searched on a warrant issued by the master. I have already spoken to the issue of the interception of communications warrants in general terms, and there appears to be some misunderstanding of intercept warrants as opposed to search warrants by which stored data, communications data, and stored communications are obtained. This type of data, that is to say, this type of data in the form of stored data, communications data, and stored communications is to be distinguished from interception, to which this bill does not apply. So the suggestion that the cross-referencing to communications data, and stored communications is a backdoor, surreptitious attempt by this government to invade the privacy of citizens is nothing more than, as I have already said, a very sad and lamentable attempt at scaremongering when we should be joining forces under Section 53 of the Constitution to legislate for the good order, peace, and governance of this country with a piece of legislation that is without question, a piece of legislation, once we pass it in this House and in the other place, that will contribute positively to the improvement of the criminal justice system. The question of interest of justice. I frankly don't understand how persons speaking to the issue of prescribing legislation with respect to the interests of justice, who are trained lawyers, can have the concerns that I heard expressed here today. There is a line of authority, of case law, that speaks in rich, sensible, and careful terms about what is meant by the interest of justice. And any judge, any master, any judicial officer applying his or her discretion in the interest of justice is going to exercise that discretion according to law and in the interest of fairness and in the public interest, so that there is no concern to be expressed seriously about the use of the term interest of justice in this fast-track trial law. A judicial officer of the quality of our judicial officers in Trinidad and Tobago is more than capable of determining the interests of justice where that discretion comes to be exercised. And I am saddened to think that there is a suggestion that that term is either not understood by attorneys at law or by the judges who will come to apply it. The issue concerning police prosecutors has also been raised. The point is that there is to be, by this bill, a consequential amendment to the Police Act with the insertion of a new section 64A to address the fact that police prosecutors will have to have legal qualifications in order to join the class of prosecutors who at the moment come mainly out of the Director of Public Prosecution's office. And what possible complaint can there be about that? The purpose of introducing police prosecutors to join the cadre of prosecutors in improving the quality of criminal justice is to encourage police officers to take advantage of the options available to them to become legally qualified, and to that extent to join fully qualified as practicing attorneys within the police service to prosecute cases that come before the courts. I can't, for the life of me, I can't understand the concerns or the criticisms that are leveled in that regard. And then there's a question of anonymization of witness evidence. Well, again, the member for Port of Spain South dealt with it quite adequately. What we are about when you look at the section is not anonymous witnesses. It is the anonymization of documents to be used in clearly articulated, particularized circumstances which involve the protection and the respect that persons who find themselves in the criminal justice system deserve if they are going to serve the interests of justice. Vulnerable persons, persons who are afraid for their lives, so that the system is allowing under this legislation for an anonymization of documents with respect to witnesses and accused, not to hide the identity of persons from those whom they accuse, but to protect the identity of persons, but who, if we look at the legislation that is before the bill, that is before this House, at the initial hearing stage, all documents, all witness statements are served within a limited period of time, in no time at all at that initial hearing stage, on the prosecutor, on the accused. So there is no question when one comes to the anonymization of documents that persons don't know who, the lawyers representing these persons, don't know who are the accusers. It is a measure of protection for persons to have confidence that they can come at their most vulnerable and be secure in their confidence that the system will allow them to get justice, will allow them to seek justice, and will protect them from the rigors and the threats that plague our criminal justice system and plague our country. Why should we bemoan the fact that in those circumstances this legislation seeks to protect persons with respect to the anonymization of documents, because that's what the section speaks to. Madam Speaker, I am not going to belabor the point. I spent a considerable period of time over 2 days, the 5th of June and today. I've put the statistics before this House, and I do not think, quite frankly, and I will acknowledge that certainly I understood the member for Chaguanas West to accept that legislation of this quality is legislation that he can support. I do not understand the scaremongering that goes with the qualified support that is being given when it is given reluctantly. The short point is, let us get on with making this a safer place in which our children, our women folk, our older folk can walk the streets of this country safely and be confident that our criminal justice system is being improved as best we can every day by the legislation that we bring to this House, and that all stakeholders in a safe future Trinidad and Tobago will join hands in ensuring that that legislation is passed. So that before I take my seat, Madam Speaker, I just wish to say that in addition to the amendment that I have already signaled, I have asked for some other amendments to be circulated. I will be seeking to bring an amendment to Clause 7, which would amend Section 5A8 by including the term stored data in that group of other language used in the section, communications, data, and otherwise, so as to harmonize the definition of stored data that is cross-referenced from the Interception of Communications Act. I've also asked for an amendment to be circulated with respect to Clause 8, which would amend Section 6(1)(a) to insert, and I acknowledge the contribution in this regard of the member of Chaguanas West, to insert the word reasonable before the words grounds for believing, so that the master will have reasonable grounds for believing that an offense has been committed. And I have circulated an amendment further, or I've asked for it to be circulated, to Clause 13 of the bill, which would amend Section 10, subsection 2A, by removing from the words, or where there is not, this is not practicable before magistrate, to be dealt with in accordance with Section 8A, as Section 8A is being deleted, and therefore those words are no longer necessary, and by amending Section 10(4) of the Parent Act by removing references to a magistrate, where the functions of magistrates are now going to be allowed for only in very limited circumstances with respect to summary offenses and the transitional provisions of the legislation. So, Madam President, Madam Speaker, beg your pardon, without any further ado, as we get about the business of the government in making this country a safer place within which we can live, I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Administration of Justice, Indictable Act 2011, Act number 20 of 2011, be now read a second time. All in favor say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Administration of Justice, Indictable Proceedings, Act 2011, Act number 20 of 2011.
The Attorney General.
Thank you, Madam Speaker. In accordance with Standing Order 68(1), I beg to move that the Administration of Justice Indictable Proceedings Amendment Bill 2023 be committed to the Committee of the Whole to be considered clause by clause.
Honourable members, the question